All right. Thank you for joining us. It's now 12 o'clock. We'll get started. I'm assuming a lot of you are eating your lunch, so thank you for joining us over your lunch hour. And we'll be happy to present to you the new conflict of interest standards. And we are myself, Carol Bach. I'm the Deputy Registrar, and I'm also a speech language pathologist. And we have
Priya Singh. I am the Director of Professional Conduct and General Counsel at the college.
Thank you. So today what we'd like to cover is a bit of background on the development of this document, including the guiding principles. We will go into a definition of conflict of interest. We'll outline the 4 standards that are contained in the document, along with some scenarios, resources as to where to find this, and supporting resources for conflict of interest practice issues. And then we'll open it up to questions. We will also stop briefly after each standard that we present and solicit any questions at that time, but we're going to leave quite a bit of time at the end for questions as well. So let's get started with a little humor.
Okay, so we have a very brief comic where there's a girl carrying a number of packages, and she asks, "Can you give me a hand with these?" Her cat, who is laying comfortably on the floor, says, "Can't, conflict of interest." She asks, "How is this a conflict of interest?" And he responds, "Helping you would conflict with my interest of not being helpful." And I think we can agree that would be a conflict of interest for him. So to begin, as Carol indicated, we wanted to give you a bit of background with respect to how the current standards came into being. So in 1996, conflict of interest regulations were proposed, and then nothing happened, essentially. So in December of 2017, Council approved a proposal to replace the proposed regulations with a more robust, more current set of standards. This project was referred to the ICRC for development, and the ICRC reviewed the proposed regulations and developed a new set of standards between April and August of 2018. They provided a draft form to Council in September of 2018, and at that time, Council directed that stakeholder feedback be sought. So, in November to December of 2018, the consultation period took place, and we want to thank all of you who reviewed the standards at that time and provided your feedback. It was extremely helpful for the ICRC, and that information was implemented on January 31st, 2019, when they took a look at the comments and what the draft standards were and created a final version of the standards. That final version was approved by Council on March 1st of 2019, and so that's how you have the current new conflict of interest standards. Now, there were certain intentions with respect to this product. The ICRC wanted to simplify and clarify the definitions, and also simplify the overall language. As I'm sure many of you know who had looked at the proposed regulations previously, some of the language was quite dense, and so in certain circumstances, it could be difficult to apply. They wanted to allow for more flexibility with the standards, and they wanted the standards to speak to both professions adequately. And ultimately, they wanted the standards to support the conflict of interest regulation, which prohibits a member from practicing in a conflict of interest under paragraph 11. The other important part of the new standards was that it would be accompanied by frequently asked questions, or FAQs, to support the membership ultimately. So something that's interesting that we wanted to bring to your attention was certain provisions of the regulations, the proposed regulations, were not brought forward. The ICRC determined that the requirement that a patient be directed to other specifically named providers if the member were to receive a benefit for the recommendation, promotion, or sale of a product no longer be required. And this was ultimately done because it really was an unrealistic way to practice. The requirements also previously didn't require that the member provide an explanation to the patient. So I can assume from the patient's perspective, it may seem ultimately confusing if I as a patient, go to Carol as a healthcare provider and she recommends a product to me, I've sought her out to receive those products. And now she's saying to me, by the way, you can go see X, Y, and Z other practitioners without any explanation as to why. It doesn't, as a patient, help me achieve that healthcare that I'm looking for. The other provision that wasn't carried forward was that the requirement that should a member be employed by a manufacturer who did not directly prescribe or sell to patients, in the event that they received a benefit recommendation or a benefit for recommending, promoting, or selling a product from that manufacturer, would have to disclose that. And they couldn't actually do that type of business in that particular employment environment. And that really ultimately didn't seem like a conflict of interest, principally because there was no direct patient involvement. A third provision that was not carried forward was the restriction against referring, recommending, or selling a product, service, or business to a patient that is not healthcare related, in which the member or related party has an interest. Now, while this may be ill-advised in certain circumstances, it really should be considered on a case-by-case basis. And so ultimately, the ICRC determined that this rule was overreaching. It really was too broad sweeping for the cases where it might be reasonable for this type of recommendation to occur. Finally, there were requirements with respect to research that were previously included in the proposed regulation. And ultimately, research isn't primarily focused on patient care, which is what the conflict of interest regulations were supposed to focus on. Importantly, there are certain rules with respect to research that are more appropriately made through other bodies, like the Tri-Council, who has a policy statement. So I just want to take you back to the consultation period. And again, I want to thank you all for providing those responses. They were incredibly helpful. And thankfully, we had 308 respondents respond to our consultation. Of those respondents, 26.8% identified as audiologists and 73.5% identified as speech-language pathologist.
Which is pretty close to our ratio of professionals.
Absolutely. And we got overwhelming feedback, which was very positive for us when we sent that out. Over 95% of respondents indicated that they either understood the proposed standards or that they understood why the proposed standards prevented a conflict of interest. Over 90% of respondents also felt that the proposed standards were realistic. And finally, over 80% of respondents agreed that the draft standards were easier to understand than the proposed regulations. And as we discussed earlier, this was one of the intentions of the ICRC when they embarked upon this project. So I'm going to take you through the principles that ground these standards. And I have a nice handy-dandy little image here to kind of display the components of the therapeutic relationship. And that's always important to remember, that within any provision of healthcare, you are engaged in that therapeutic relationship. And it's based on power, respect, closeness, and trust. And in particular, trust is crucially important in that relationship, because patients come to you trusting that when you make a recommendation, it's for their best interest. It's necessary for their healthcare, and it's not for your best interest as the healthcare professional. They trust that your professional judgment is not influenced by your own personal or financial interests. And this is important because in that therapeutic relationship, there's always that power imbalance. And so when a patient comes to you, they come to you knowing that you have a certain authority because you possess a set of knowledge, skill, and judgment that they themselves don't have. So if I need a speech-language pathologist and I'm going to Carol, I'm going to her not because she's a colleague and a friend, but because she's a speech-language pathologist, and I trust that she has the knowledge, skill, and judgment to be able to make the appropriate recommendations that are best suited for me. Another important principle that's grounded in the standards is from the Code of Ethics, which states, under Article 4.2.6 that all audiologists and speech-language pathologists shall avoid activities that could be construed as involving a conflict of interest. And ultimately, it's important to remember that a conflict of interest will undermine trust, and this can lead to a breakdown in the therapeutic relationship.
Mm-hmm.
So I'm going to turn it over to Carol to discuss the definitions.
Okay, thank you. Yes, I think we all have an intuitive notion of what conflict of interest is, but it bears explanation, I think. Just a bit of humor. So in case you can't see that, this is a truck that on one side says it's a funeral service, and on the back it's an ambulance. So clearly that driver has a conflict of interest. Hopefully you're not in that situation. But here's some of the highlights of what we consider a conflict of interest. It occurs when a reasonable person could conclude that the professional judgment of a member is influenced by their own personal or financial factors, and that those factors place the member's interests above the patient's interest. Mm-hmm. And you'll find that definition in the document. The conflict of interest, therefore, can be an actual conflict of interest, a potential one, or a perceived one. So let's move on to cover the 4 standards that encapsulate guidance for you in terms of a conflict of interest situation. So standard number 1 states, members must not provide a benefit to another person or agency or receive a benefit for a patient referral. This is common across all healthcare professionals, that basically you cannot pay for a referral or receive payment for providing a referral. This includes making referrals for healthcare to a relative or business partner where you directly or indirectly receive a benefit. For example, your husband's a psychotherapist and your patient appears to need counseling. You refer to your husband. You live together. You benefit from your partner's increased revenue. You are indirectly receiving a benefit for that referral. And based on that principle, recommendations, or this concept is based on the principle that recommendations should be based on the basis of the patient needs. And a second principle is that wherever possible, that you should be providing patient choice. Being paid in some manner for making a referral puts the healthcare professional in a conflict of interest, or at very least, it appears to. Okay, so this is our first polling question. And bear with me, I'm just going to get us set up. But does this mean I cannot refer to anyone I know personally? So your choices are correct, incorrect, or it depends. And I'm going to open the poll, and you should see it appear on your screen in just one moment.
Yes, that's it.
Mm-hmm. Okay, so you should see it on your screen. I'll give you a minute or two to weigh in. Okay.
I feel like we should have some background music at this point.
All right. I'll show you the results once I give you enough time to vote. We've got about a quarter of you, third of you voting. Let's get it up to 80% voting. All right, we're getting close to the majority of you have voted. I'm going to close it up, and I'm going to show you what you voted. So, as you can see, most of you said it depends. Let me tell you, that's always a safe answer with the college. And especially conflict of interest, it's often contextual. 20% said incorrect. which I can certainly understand why people might choose that option. But let me take this away and back to our slides and show you. Oh,
Oh, there you go.
oops, there you go.
Perfect.
It depends. And it depends on whether you're receiving a benefit from making the referral. Simply because it's somebody you know personally does not mean you're obtaining a benefit. If you're not, it's fine. But if you have some kind of arrangement with your friend that I will only refer to you if you only refer to me, that kind of arrangement is a benefit for your referral because you'll get referrals back, and therefore it's not okay. That is receiving a benefit for your referral. So well done on the people who picked it depends. All right, let's move on. Let's look at standard 2. So the second standard is members must manage or resolve unavoidable conflicts of interest appropriately. We recognize, as I'm sure you do, often there are conflicts of interest that are inherent to the job. In fact, being paid to do your job is an inherent conflict. You could make the argument that you want to have enough patients so that you continue to be employed. So we all have to deal with a certain amount of conflict of interest. But let's look at these, some of the more common ones that are a little more extreme. So you sell the employer's product. For example, you work for a manufacturer clinic. That's a common one. Another common one, maybe more in the speech pathology world, is your employer limits your treatment approaches. So there's lots of organizations that offer a mediator model type service, like the Hannon program, for instance. So if the conflict of interest is unavoidable, you must mitigate the impact in the following ways. So number one, you need to disclose and discuss the nature of the conflict of interest with the patient before providing the services or continuing to provide services. Second thing you must do is make the patient aware of practical alternatives where possible. Thirdly, you need to then ensure the patient consents to proceed with whatever services you're offering or products. So let's just talk about another common conflict of interest, and then we'll go to a polling question. So another common one that arises is when you provide private services, they're also offered by your employer. So for example, the family of a child who's waiting for your agency who employs you, waiting for their treatment block to begin. And in the interim, they want you to provide private therapy. Before you do, again, this is something that you must mitigate. And the way you do that is, number one, again, inform the patient that the service is being provided independently of the member's employer. So you make it clear, this is a private service you're asking for. It's not part of my service with the agency. Give the patient the option of selecting an alternative service provider where possible. So in this particular type of conflict of interest, we are requiring members to say, yes, I can provide you private service, but there are other people that provide private service, and you can either direct them to the Oslo website or what have you. And then also discuss fees to be crystal clear. And then again, ensure that the patient understands and does explicitly say, yeah, I want to go with that. Okay. The other thing just to note in these kinds of situations, we're not suggesting that we are allowing you to do this. It really is dependent on your employer. So we assume that you check in with your employer to see if you are able to provide services privately. Okay. So in these two common conflict of interest situations, I've outlined the steps you need to take. The last step that you need to take for all of these is to document that you've taken these steps and document it in the patient record, because essentially this is part of obtaining informed consent. Patients need to make an informed choice, and describing and outlining what the conflict of interest is that might influence their decision is an important piece of information that goes into obtaining informed consent. So you must document. All right, let's go to poll number 2. I'm not going to raise the poll up for this one. We're just going to run through it, and you can listen and think about what your response might be. So my employer is also a hearing aid manufacturer, and as such, I'm encouraged to sell their product. And the way that they encourage me is they're offering an interest-free loan for clinic upgrades based on my sales. So can I accept this offer? So your options are: yes, the patient would assume I get these kinds of offers, so there's assumed consent. And I think what we're thinking here is, the name of the clinic and the advertising within the clinic might speak to that manufacturer's product only. So there's assumed consent there. No, number 2, no, it is a conflict of interest and must be avoided. So you can't enter into that situation at all. Or yes, if I disclose the incentive and offer a practical alternative. Or obviously, number 4, I'm not sure. So we don't have the poll for this, I apologize, but give it some thought, decide what you think is the best answer, and I will move to the best answer. Yes, if I disclose the incentive and offer a practical alternative. Again, thinking back to some of the common conflict of interest situations that I just discussed, some of them are unavoidable. A manufacturer-owned clinic is going to want you to sell their product. However, you need to tell the patient, look, I'm recommending this product for you. I think it is the best for you. I also want you to know that I get an incentive for selling this particular product or line of products. And there are definitely other vendors that you could go to. There are other products that I could also sell you, but I actually think this is the correct product for you, regardless of the incentive. It's up to you. So you give them that option. And obviously, the presumption is you are recommending the most appropriate product, regardless of the incentive. So you can say that genuinely. All right. So let's move on to standard number 3.
Perfect.
Priya,
Thank you.
Take it away.
Okay, so I'm just going to start off with a quick comic where clearly a senior employee is introducing this gentleman's new boss, and he says, "This is my nephew Skippy. He's your new boss." I'm sure this is going to be a very interesting employment relationship. And it leads us nicely into standard 3, which states that members must not enter into an employment agreement whereby they clinically supervise the person who employs them. This involves a situation where the member, such as yourself, is employed by someone whom they are responsible for supervising. Now, why is this a problem? It's because there's an inherent tension between your personal concern to maintain employment versus providing appropriate supervision. So for instance, Carol is my boss, but I also have to supervise Carol's work. So I'm going to be, reasonably so, a little concerned by saying to Carol, I don't agree with your opinion. I think you need to provide different services, because the response will likely be,
you're fired. And I continue to provide poor service to the patient. So that's the concern for the college.
So we have the third polling question for you. And the scenario is, I have a job offer to supervise communicative disorder assistants, CDAs. The practice is owned by a CDA who employs many other CDAs, and she offers speech and language treatment to children. She would be hiring me to assess children and then supervise her other staff CDAs as they provide treatment. So the question for you is this a conflict of interest situation that is prohibited. So I'm going to open up the polling. Nope, that's the right one. Yep. Make sure I'm opening up the right poll. I'm going to open up the poll for you, and you should see the options, which are yes, I cannot be employed here because the employer is a CDA who is a professional I will supervise. 2, no, I am not required to supervise my employer. Or 3, maybe only certain CDAs can provide supervised treatment to children. And I'm going to leave it for a moment while you vote. We really should have put some background music on this. Just going to give you about a minute to vote. So it looks like we've got slow trickle of responses coming in. Don't think we've stumped them.
No, it's a little mixed.
Yeah. I'm going to give you a couple more seconds, and I will close the poll now, and I will share the results with you. So as you can see, 25% of our viewers today responded that yes, I cannot be employed because the employer is a CDA. 62% of you said no, I am not required to supervise my employer. And 13% of you responded with maybe only certain CDAs can provide supervised treatment to children. So I'm going to hide the poll now and move on to the answer. So your answer is no, I am not required to supervise my employer. In the scenario that we provided to you, the employer may be a CDA, but in the employment situation that was described, you would not be required to employ or to supervise your employer. However, that said, it's always important to be clear whom you will be supervising, what your role is in the organization, and what duties you will be responsible for ultimately. While this may be a situation where initially I'm hired and I'm not supposed to be supervising my employer, say Carol, there may be a situation where Carol says, you know, I need you to supervise this patient for me. And so it's important to have those clear parameters set up from the beginning so that you don't end up in that type of situation. Because most of the time, conflict of interest situations happen gradually. They happen almost subtly in many circumstances. And so you might not even appreciate that you're in a conflict of interest until it's too late. So our fourth standard starts out with a physician offering a prescription to his patient in which he says, try this, I just bought 100 shares. Reasonably speaking, he did disclose his interest, so at least that part wasn't hidden. This takes us into the fourth standard that says members must not enter into an agreement with any person or agency that limits the member's ability to exercise their professional judgment to provide appropriate recommendations. Now, the reason for this is while you may receive benefits from manufacturers for prescribing or recommending products, and that obviously is with the caveat of standard 2 that Carol discussed, you must not enter into an agreement that requires you to exclusively recommend a product or service. Why? Because this ultimately restricts your professional judgment. You again are the healthcare professional with the knowledge, skill, and judgment to make the recommendation that's appropriate for the needs of your patient, and presumably not that's most beneficial for an agreement that you've already entered into. So your fourth polling question is a scenario. A company is producing an app for language development and they have approached you to recommend their app exclusively. They will pay you 5% of sales stemming from your recommendation. The question is, can you enter into this agreement?
Do you want to go to your
yeah, that's probably a good idea. So your options are, yes, the treatment plan is based upon the patient's needs and this app could be beneficial. 2, no, by agreeing, you would be entering into an exclusive agreement. Or 3, no, you can only receive 1% of sales, which is more nominal, and that would be acceptable. So now I'm going to open this poll up, and it should be on your screen now. And we're just going to give you a moment to vote. Don't be shy. Well, it looks like everybody is, oh, I spoke too soon.
Yep, 17%.
Yeah. So we're at a half a minute. I'm going to give you another half minute to input your votes while we watch intently as they stream in.
It's interesting because I think people are thinking initially, then it swells and then recedes. So.
And I'm sure many of our viewers are in conversation with their colleagues right now, debating.
That's fabulous.
Okay, so I'm going to close the poll now, and I will share the results. So as you can see, 7% of our viewerships indicated that yes, the treatment plan.
9%.
Oh, sorry, 9%. 9% indicated yes, the treatment plan is based upon the patient's needs, while 91% responded with answer 2, no, by agreeing you would be entering into an exclusive agreement. So I'm going to hide the poll results now, and we're going to move on to the answer, which is no. By agreeing, you would be entering into an exclusive arrangement. This arrangement would constitute an exclusive agreement, and even if the app was appropriate for most of your patients, this situation would create the environment where you would be unable to recommend any other app. And so ultimately what this is doing is undermining your professional judgment to make appropriate recommendations, again, based on your patient's needs rather than your own financial incentive. When making recommendations, we go back to what we discussed in the beginning, patients trust that important part of therapeutic relationship. Patients trust that this is done for their best interest, that all recommendations or treatment plans are done for them, exclusive to them in their best needs. So Carol's going to take you through where the conflict of interest standards are found on our website.
Thank you, Priya. I'll show you in the slides, just so you know where I'm going, and then I'll take you onto our website. But if you've been on our website recently, you'll click on resources, then you'll see there's a box for standards and resources. Those open up to several content or topic specific boxes, and there is one for conflict of interest. And within there are the standards in both English and French. So let me just, you can watch me do this. It's always fun to watch somebody else on the internet, but I'm going to do it anyway. So you click resources, scroll down, standards and resources. And while I'm here, I might point out that things have been reorganized, and we think it's much more intuitive, and our feedback so far is that's the case. You will see there's profession-specific information. Today, we're really talking about conflict of interest, and there it is. And FAQs, as Priya mentioned, these are FAQs that have been there for a while. We will be, once we get more questions, because this document's just been launched, there will be a conflict of interest set of FAQs, and they will go here. So that's where that is. And let me bring you back.
Get to the PowerPoint.
Oops, there we go. Can't see it.
There we go.
Camera's in the way. So we'll go to, yeah, there we go. Perfect. All right. So that's where you'll find the resources. Mm-hmm. So let's summarize, and then we will open it up to questions. In summary, when you are faced with a conflict of interest, and you can't avoid it, you must be transparent with your patient. That's one of the primary principles, transparency. Mm-hmm. And another underlying principle is you must be honest with yourself. So Priya had a funny little cartoon about the doctor with 1,000 shares or 100 shares in a drug company, and he's recommending it. Is he biased in his recommendations because of that? And you always have to take that internal deep dive with yourself to see, are these incentives, even though I've disclosed them, are they influencing my professional judgment? And obviously, if the answer is yes, then you really need to rectify that. Okay, so we have Alex Carling off to the side. She's our practice advisor, and you often call her for more detailed responses and answers to conflict of interest, but she's going to reflect some of the questions that are coming through on the system.
Certainly, so everyone will hear my disembodied voice. So just if you do have a question, just type it in. You'll see a box for questions. Just type it in and send it to us.
Yeah.
We look forward to answering them. But we do have one,
Okay.
and that is, to be clear, an audiologist who works for a manufacturer-owned clinic needs to let the public know if they are prescribing that manufacturer's hearing aid. And the audiologist then needs to let the public know if they get a commission on the hearing aid that is sold. Is that correct?
Yes, they need to disclose the commission. And they also need to be in an environment where they can recommend other products if they feel that that's best for the client. I think in the audiology world, very often manufacturers, a particular manufacturer makes a suite of products that generally will meet the needs of a patient, but you need to be able to recommend something else in those perhaps unusual situations that you feel your patient needs. So presuming that's the arrangement, then yes, you're disclosing that this particular product, I have an incentive for selling it, or I have an incentive for selling this manufacturer's products, and this is what it is. But I do think this is the best product for you. And you are welcome to, seek out another opinion or seek out another vendor. But this is what I recommend.
Excellent. So completely changing the topic. I work for a private healthcare agency providing adult home care services. I am trying to recruit another SLP. An SLP contacted me, and she actually works for a publicly funded agency, but it's a preschool agency. And don't forget, the person who has the private company is providing adult services. She was told by her manager that she was unable to work for my company, and that the agency as it is in a conflict of interest. I did not understand her rationale. Is this a conflict of interest?
It ultimately would be difficult for us to answer that because we don't know what the requirements for that member's employment relationship is. Often in these types of situations where you're hearing details third and fourth party, some pertinent information may be missed. So in that circumstance, I think the best thing for the member who had the conversation with their manager would be to carefully review their employment contract as well as the policies of that employer to determine exactly what they can and cannot do, because without further information, it really would be difficult for us to say one way or another as to whether that member would be practicing in a conflict of interest.
Yeah, and ultimately, not being flip, it doesn't really matter what we think. If the employer has that prohibition, then they need to abide by that. I suppose they could get into some kind of legal battle with their employer, but that would be all about the Employment Act and getting into that. But absolutely, if the employer says you can't, then I think that member would have to abide by that. And yeah, I mean, I don't know. Maybe that agency does also provide services for adults, and that member isn't involved in it, but I don't really know. But as Priya said, that would be their purview, and you'd have to dig deeper. That member would have to dig deeper with their employer.
Okay, thank you. Another question. A member is practicing in a publicly funded situation. Someone wants a recommendation for a private SLP. Should the member working in the publicly funded situation recommend several options?
Can I?
Absolutely.
I'll jump in. I think providing a name of somebody you know is not inherently a conflict of interest. So I don't think it really, that situation necessarily speaks to an issue with conflict of interest, unless, of course, as we said earlier, that person's getting some kind of benefit for referring to their friend, and really do a deep dive on benefit. If that friend takes you out to dinner once a year at a lavish restaurant for all the referrals you gave her that year or him, then arguably that's a benefit, and you really should avoid that and give alternate names. But I think in terms of transparency and providing choice, it's not a bad idea to provide a choice. On the other hand, I do think members of the public are often looking to professionals to send them to somebody they know works in that area and is competent. And I think that's a reasonable expectation. And if you feel that person's very competent, and that's the person you know who's competent, and you're not receiving a benefit, then it would not be a conflict of interest to send the client on to that person.
Thank you. So with respect to the example of the app for the SLP, would that SLP be in a conflict of interest if another product is available to offer? So if they are able to offer a number of products?
As long as they disclose, I think that is really more about disclosing the conflict of interest. So their app might be fabulous. And there may be some others that aren't as good. That's genuinely the member's opinion. They can tell them that, but they would also need to say, I benefit from selling this app. So you need to know that. And there are others. They wouldn't be my top recommendation, but they are also available to you, and let them make the decision.
We have another audiology question. What if the retail clinic and the manufacturer are owned by the same parent company, but the manufacturer does not own the retail clinic?
Say that again. So the manufacturer doesn't own the retail
No,
clinic?
there is a parent company, excuse me, that owns the manufacturer, but the manufacturer does not own the retail clinic.
So what's the question
what's
in
the
that
question
circumstance?
So I would assume, are they still required to declare any benefits?
Are there benefits involved in this? I think that we should probably separate out a little bit between, I work for an organization that is a manufacturer, and I sell their products.
Right.
Versus I get a benefit for selling these, additional benefit. I get incentives for selling these products. I think when we talk about conflict of interest, we're really talking about when that benefit gets introduced, now you're in a conflict of interest. And you need to, depending on the situation, either you can't recommend anything else, and that's problematic, or you disclose the benefit. So I'm not hearing what the benefit piece is. So we'll, and any questions that don't get answered, we should mention. Please email us, and we'd be happy, or practice advice, SLP practice advice, and then there's audiology practice advice at CASLPO.com. And we'll be happy to answer any of these questions that we don't get to today.
Absolutely.
Okay. If a member is married to a physician and that physician is asked to provide names of private SLPs in the community, can the physician include his or her spouse's name on the list of private SLPs and disclose the name of his or her spouse?
I think in that circumstance, that question should be directed at the physician's regulatory board, because the physician would then be responsible for adhering to the conflict of interest rules, regulations, or standards coming from, I guess in this circumstance, it would be the College of Physicians and Surgeons of Ontario.
Okay. Right. In my organization, I have been asked on 2 occasions to provide private services to a child after they have been discharged because they started senior kindergarten. Okay. My employer feels this is a conflict of interest, so I have not provided the service. Does my employer really have the power to tell me I may not provide the service?
I think, again, it goes back to the employment relationship between the employee and the employer. There could be contract provisions within that employment contract that restrict you from, say, providing services for up to 1 year after discharge. And so I guess in some ways the answer is yes, they really do have the authority, but it is always dependent upon the employment relationship as well as what policies employees of that particular employer are obligated to follow.
Absolutely.
Okay. I work for a school board. What if parents are asking for my services privately while the child is on the waiting list at the school board? However, I am the SLP in charge of the waiting list at the school board and chooses who comes off the waiting list for school board services. So I have, I'm in charge of the waiting list at the school board, but I also see children privately, and some parents are asking me, they've got my name, to provide private services.
That's a difficult one. I think in those circumstances, and Carol can certainly disagree with me, I think in those circumstances that might be a situation where the conflict of interest can't be managed. I don't know that in that circumstance you can reasonably demonstrate that your own personal interest didn't come before the control of that list. And I think that particular role, being able to control who comes off the list and who remains on, is an important caveat to weighing whether there is a conflict of interest. And that really goes to the crux of many conflict of interest situations, as Carol indicated earlier. Sometimes it depends. Sometimes there are varying factors that could make a situation a manageable conflict of interest, and unfortunately sometimes there are not.
Yeah, I would agree. I suspect you're posing the question because it does feel like it's pushing the limit. And I think you always have to, as I said earlier, I think you really have to look inside and decide beyond applying these rules, because I think technically what this set of standards is saying, if you disclose it, then you're okay. But also what we're saying is, as a self-regulated professional, you have to do a little bit more of a deeper dive and really decide for yourself, do I feel comfortable with this? Does this feel a little uncomfortable? Do I say to the parent when I disclose it, I really think it's not a good idea, because I do look at the wait list, and even though consciously I'm not going to move you, I don't know if this influences me more. Let me refer you to somebody else. And then to add another layer of uncertainty, I'm sorry to do this, but it's not Priya or I or Alex that makes the ultimate decision. If somebody sees that and feels it's a perceived conflict of interest and makes a complaint, it would be a panel of your peers that would look at it and decide. But if you're not sure, I think sometimes it's just easier and you sleep better if you lean on the err on the side of over diligent.
Sometimes we say, when in doubt, bow out.
Thank you. Will the language in the Code of Ethics be changed? Are we thinking of that at all? Any of the situations you have just given could be construed as a conflict of interest, and therefore by the Code of Ethics should be avoided. So I think the person asking the question just wants to know, perhaps add clarity of language in the Code of Ethics given the new standards.
That's an interesting point. I think the reason we created this standard is to provide clarity to those types of statements. That there is also the professional misconduct regulation that has similar language, and taken on on its surface, it's very black and white. And we all know that conflict of interest is very contextual. To try and capture it in a short document that tries to be all-encompassing, like the professional misconduct reg or the bylaw for Code of Ethics, it would be duplicative. I think our point is that conflict of interest needs to be defined in a broader contextual way that changes with the times, and that's what the standard is for.
A couple of clarifying questions here about the app. Okay, so is a conflict of interest avoided only if another app could be recommended?
So I think the example with the app was really meant to demonstrate that you are not supposed to enter into an agreement where you can only recommend a specific product or service. So the example in that circumstance was the app. If you do have a number of apps available, but you genuinely believe that, say, app 1 is much better than app 2, and you're not receiving any financial benefit from making the recommendation for app 1 as opposed to app 2, there's no conflict there. You are exercising your professional judgment and making that recommendation based on what you feel the patient's needs need, essentially. It's when you're entering into an agreement where you can only make that recommendation for that app and you're receiving a benefit, that's where the conflict of interest occurs. So I'm hoping that maybe clarifies the questions with respect to the app.
Yeah, and the other scenario, is it's your own app. There's no other app that even comes near. That isn't an agreement, an exclusivity agreement at all. That's just you produce something that nobody else has, and it's very unique. So we wouldn't consider that an exclusive agreement. You could recommend it, but again, you'd need to disclose that you get money for selling that. It's your app.
So a couple of questions here regarding SLPs working, let's say, in a school board.
Sure.
The parents ask for more service. Maybe you're only consulting, maybe there is a block situation of block therapy. The parents want you to provide the service. They know it's private, but isn't that a conflict of interest? That was the question.
Oh, okay.
Isn't that a conflict
I thought you were
of
adding
interest?
inflection.
Yes.
Yeah.
Yes, but once you disclose it and give the patient a choice, then you are mitigating it. It is but again, if you feel very uncomfortable with that, then I would say don't provide the service. But our perspective is protecting the patient, but we don't want to protect them to the point where they have no access. If you're in a small community and there's no other private person and they have the resources and they would like you to do this and your employer allows you to, and you're completely transparent about it, I don't think we want to put things in place that would prevent that parent from getting some help that they would like to pay for. So again, there's a limit to defining conflict of interest and then putting a hard line, a hard bar against it from our perspective.
This isn't strictly conflict of interest, but it is a question nevertheless. So I work in a school board, I make a recommendation or I give a list of 4 or 5 private therapists. The family go to the private therapist and it turns out to be a disaster and they make a complaint. Would I ever be involved in the complaint because I recommended that person or because they were on my list?
Ultimately, yes. Anybody has the right to make a complaint against a member of the college. There is no restriction as to the chain of events in which one can make a complaint. It may be that the complaint is against the member that you referred to, so you may be involved in the investigation, just for clarification as to what recommendations you made and other healthcare providers, but it's entirely possible that the family could make a complaint against you and the healthcare provider that you ultimately recommended.
Yeah.
Going back to audiology question now. In the scenario where the audiologist works for a company whose parent company also owns a hearing aid manufacturer, if the audiologist only receives an incentive for selling a hearing aid, not necessarily the sister manufacturer's hearing aid, would the audiologist still need to declare to the patient that relationship?
Yes. That's
simple. You're getting a benefit for sales.
Yeah.
So you would need to tell that patient, you know, I have sales targets for any of these products I sell, and you know, I get a benefit when I hit my targets. Again, it's a conflict, it's a potential conflict of interest that you need to disclose.
And I think it's important to take it from the perspective of the patient. They need to know what factors could be influencing your decision. So if you, for instance, were going in to, say, buy a car, and the top of the line model is also going to be sold with an incentive to the salesperson, whereas the bottom 3 models may not be. And so the salesperson is really pushing that top of the line model to you. From your perspective as the consumer, would you not want to know that there is that incentive, and that may be the reason why they're pushing it? So the important part here is to make sure that you are transparent with your patients, to let them know all the factors that are involved in why you're making certain recommendations. A part of that will be that, in your professional opinion, you feel that that particular product is going to meet their needs, but also that you are receiving a benefit above and beyond, say, your regular pay.
Right, right. And the difference, I think, too, between those two scenarios is that when you go into a car lot, you know.
True.
You go in with the assumption they've got all sorts of incentives and benefits for
Absolutely.
selling you the top of the line.
Absolutely.
As a patient that is vulnerable because you have a healthcare issue, it goes back to the trust. You trust, you don't necessarily think that. So disclosing it in some ways will build the trust, I believe, so that they understand and that you are making your best professional judgment, and they need to know this. And from audiologists I've spoken to, they find that this builds trust. The patient rarely says, oh, okay, well, I'm going down the street, because they've built a relationship and trust, and this transparency only adds to that trust. We're just at 1 o'clock. Do we have a quickie?
Well, just a very quick question. This is different and quick.
Okay.
We are often invited by hearing aid companies to an educational launch of a new system. If it's not close, they'll pay for our transport, even a hotel. They'll give us food, but it is educational. We are learning about new products. Are we in a conflict of interest if we accept their hotel and food and travel?
No. You're not getting benefit for selling the hearing aid to the patient. That's where the rubber hits the road.
Absolutely.
Thank you.
Okay. All right. Thank you so much. And as I said earlier, if you have any further questions, please email them to us and we'd be happy to answer them. And Alex?
We have a couple more questions. We can print these out and we can get back to those members whose questions weren't answered.
And these will be the body of our FAQs that we referred to earlier, so that thank you for helping us make this document what it is, and also the FAQs that will follow. Thank you.
Thank you so much.